a cargo de la señora Jayashree WATAL, experta en propiedad intelectual y transferencia de tecnología. Ella es consejera de la División de Propiedad Intelectual de la OMC. La señora WATAL es también profesora adjunta de Derecho de la Universidad de Georgetown. Tiene más de 22 años de experiencia de trabajo en el sector público en la India, de los cuales dedicó alrededor de 10 años en la elaboración de políticas, investigación y administración de los derechos de propiedad intelectual. Ha trabajado como directora de la División de Políticas Comerciales del Ministerio de Comercio y ha representado a su país durante las negociaciones del Acuerdo de los ARCTIC en la ronda Uruguay. Es escritora de diversos artículos en materia de propiedad intelectual, los mismos que han sido publicados en reconocidas revistas internacionales. ¿Puede empezar, señora WATAL?
Buenas tardes. Voy a presentar en inglés porque no hablo español muy bien, muy poquito. So this is an introductory lecture. It is going to be a presentation on the TRIPS agreement and its relationship, of course, to technology transfer, which we will see as we proceed in this seminar. I have been asked to make some 6 presentations in the seminar, so you will see a lot of me, I think, in the next few days. This is the structure of my presentation. I'm going to tell you a little bit about intellectual property, what it is the economic rationale for it, what kind of legal protection does intellectual property entail. The TRIPS agreement itself, a little bit of the background, the provisions, the functioning of the TRIPS Council, how does it function, and how are disputes settled in this area. So this, you recognize something about intellectual property in this picture. The first is a book that is covered by copyright protection. McDonald's, you see that? That's the trademark, so it's protected by trademark. You have integrated circuits, with the chip, the semiconductor layout design, as it's called, that is protected also by a special kind of intellectual property. But it is also protected, it could also be protected by patents. You have a bottle of champagne or wine, which is protected by geographical indications. Carpets also could be geographical indications, and so on. So this is just to tell you that there are different kinds of products which are covered by intellectual property. But what is the rationale behind the protection of intellectual property? Intellectual property is a very broad term, and there is a certain economic rationale behind its protection. This is generally considered the rationale. Useful information, or what we call knowledge, possesses certain characteristics of public goods, global public goods, you could say, public, that is goods of public interest to the whole world. Now, a public good, by definition, in economics, consists of 2 characteristics. One is that it is non-rival in consumption. That is, my consumption of it does not reduce your consumption. So it's not like a sandwich, which if I consume the sandwich, then there's nothing left for you, right? So unlike that, knowledge or useful information can be shared. If I consume or use that useful information, that doesn't prevent you from using that. So it is non-rival in consumption. Similarly, it's non-excludable. That is, nobody can be excluded. Once it is out, that useful information, once it is available, it is difficult to exclude anybody from using it, except if you have intellectual property. So that is the rationale. Because if you did not have intellectual property, you wouldn't have this, you would have everybody using it. So creative and inventive works are covered by intellectual property rights because there is a high cost in the production of such creative and inventive works or knowledge, and there's a low cost in reproduction. And typically, in cases such as computer software or medicines, where there's a high cost in producing that knowledge, but a low cost in reproduction, if there were no barriers to entry, if everyone was allowed to copy, then very few people would invest in devoting resources to the production of such knowledge. And competitors could free ride. So there would be no reason for anybody to invest in intellectual property. Similarly, even with intellectual property rights, the benefits of such useful information or knowledge are only partially appropriated to the private person. The benefits to society are much larger of a new work, new invention, in the case of inventions, or new works, copyrighted works. So there are what economists call positive externalities, where the benefits to society are greater than the private profits. And this happens even with intellectual property. So society has an interest in creating more and more such useful knowledge. But intellectual property rights are not the only way to capture the profits from the use of such knowledge. You have also lead time, which is to be the first in the market, to be the first to produce that product. That is called lead time. And you can also use secrecy. Secrecy means you keep it secret. Coca-Cola, the best example of a trade secret. But processes can also be kept secret. Chemical processes in particular. What is the additive? What is the catalyst that is required to make that particular chemical? That can be kept secret. You also have after-sale service, where in certain industries, it's not because you have a patent that you're going to have a competitive edge. It's because your after-sale service is better, that your product sells better than other products. So complementary sales and manufacturing capabilities, that you have spare parts, for instance, in certain cases, that could be a capability that gives you the edge. Or you have rapidly learned, you go rapidly up in the learning curve, that could be an advantage. You have tacit knowledge, that is the same as trade secrets. And you could also use trademarks to capture profits. So you already made a reputation, your reputation is already quite good, so you ride on that reputation of your trademark. Technological protection is getting increasingly important. And what is technological protection? It is protection, for instance, of copyrighted material on the internet, that you cannot download something, or you can only download it once, and after that the file gets corrupted or CD gets corrupted in some way. Similarly, you have seeds where you produce it, you sow it once, the seed, you get a crop out of that, but the next crop does not have the same quality as the original crop, so original seed. So you genetically engineer the seed so as to not produce the same quality for the next crop. So if you save the seed and you sow the seed the next time, you will not get the same quality of the product. So you don't need intellectual property protection, you just use technology to make sure that nobody can copy or misuse the seed. Because you force people, you force the farmer to go to the market for each crop, to buy the seed fresh for each crop. So that is technological protection. This is getting increasingly important in certain fields where it is possible to do that. But intellectual property rights still remain important, and this is why we will talk about intellectual property. So what are intellectual property rights? The WTO has this definition on their website. Intellectual property rights are the rights given to persons over the creation of their minds under certain terms and conditions, or certain conditions and obligations, to be more specific. So what are creations of the mind? Creations of the mind can be, an author has written a novel, that is the creation of the author's mind. It is created in the author's mind, and therefore It comes in the form of a novel, which is covered by copyright. It could be a film, it could be a work of art, a painting. It could be a code, which is software, that is covered also by intellectual property. It could be an invention, which is useful. It could be a trademark, which is also, in a certain sense, a creation of the mind, because the name which you give to your product is something which you take from somewhere, which comes from the person who's giving the name. But all these conditions, these rights, are given under certain terms and conditions. So they are not absolute. It's not like your property, it's not like normal property, where if you have a house, for instance, you can occupy it, you have every right within your house, right? Here, the state grants you the intellectual property rights, and they are always subject to certain terms and conditions. Usually, what the right gives you is the exclusive right, that is, right to exploit your invention, but to prevent others for a limited period of time from using your invention or creation without the authorization, So you have the right to authorize the use of the creation or invention. You don't have the right to actually exploit that invention or creation yourself. That could be governed by other rules. For instance, a film. You have copyright over the film. Upon creation, you get copyright with no further formalities. But the film can go through the censor board. It can be censored. So that means there are certain restrictions. So you don't have the right to use it till it is passed by the censor board, for instance. Or you have an invention, which is a medicine, but you don't have the right to sell the medicine because it may have to go through marketing authorization to show that it is safe, etc. It has to go through some kind of approval process, regulatory approval process by the health authorities. So that is why intellectual property rights are called negative rights and not positive rights. The example of the patent, exclusive rights are given for a limited period of time for eligible inventions, but with an obligation to fully disclose how you make that invention for purposes of determining or dissemination of the knowledge and technology. And it's also subject to certain limited exceptions. Now, dissemination of knowledge, dissemination of the technology is the purpose of the patent. In exchange for the grant of the patent, the state grants a patent in order to get to the disclosure which is in the patent application. Now, these are fundamentally different concepts, whether it's copyright or patents, or whether it's trademarks or geographical indications. The concepts have different economic effects. One category of intellectual property is that which aims, the goal of which is to stimulate inventive or creative activity. Patents, copyrights, industrial design, plant breeders' rights, layout design for integrated circuits, utility models, trade secrets. All of this is aimed at stimulating innovation or creative activities. There's another kind of intellectual property, which is trademarks and geographical indications, which are distinctive signs put on products or services even. And that aim or purpose, economic purpose and even effect, is quite different, because the purpose is to resolve information asymmetries. What is information asymmetries? It's where the buyer has less information than the seller. So there is an imbalance between what the buyer knows, the buyer has much lower, and the seller has perfect information on what is the quality of his product, etc. So there is this asymmetry, which is corrected by trademarks and geographical indications, which gives you some information because of the reputation of that trademark. So from the lawyer's perspective, you have copyright and related rights, and you have industrial property rights. So this is the way lawyers look at it. There are two categories of intellectual property rights, copyright and industrial property. And then you have sui generis, which is unique, one of its kind, which doesn't fit into either copyright or industrial property, such as plant breeders' rights or layout designs. These are typically put as sui generis methods of protection. But from the economist's point of view, you have the effect, the goal, which is those that stimulate inventive or creative activities, and those that resolve information asymmetries, which I explained to you in the earlier slide. Now, that is about intellectual property in general. What does the TRIPS agreement say? The TRIPS agreement is contained in Annex 1C of the WTO agreements, which is a legal text, the Marrakesh agreement. But why was intellectual property brought into GATT when there is a specialized body or UN agency for intellectual property called the World Intellectual Property Organization? Why then was the international agreement on intellectual property not negotiated in WIPO? Why was it brought to a trade body, which is the General Agreement on Tariffs and Trade? That is, in the Uruguay round, there was a proposal to bring intellectual property into the trade rules system. So I'll explain a little bit about that. This TRIPS agreement is really the most comprehensive body, the most comprehensive agreement, the most comprehensive treaty, which contains international rights and obligations in the field of intellectual property. Now it surpasses every other treaty that existed prior to TRIPS, such as the Paris Convention, such as the Berne Convention, and so on. These are all treaties that are administered even now by the World Intellectual Property Organization. But in the Uruguay round of trade negotiations, that was from 1986 to 1993, in that 7-year period when the Uruguay round was negotiated, many issues came up in the TRIPS agreement, not only North-South issues, but also North-North issues. That is, issues between United States and the European Union, for instance, on geographical implications. There were many differences between these two major blocs in the developed world. At the end of all these negotiations, the result was the TRIPS agreement. So a lot of people have said that the TRIPS agreement is not in favor of developing countries which do not produce the technology and therefore have no interest in protecting intellectual property. So why did the developing countries in the end accept the TRIPS agreement? Because there were trade-offs. There were trade-offs in the Uruguay round, as there are in any trade round, especially when the round is taken as a single undertaking. There was textiles, agriculture, where certain countries saw advantage in those areas, and in return they accepted the TRIPS agreement. That is one explanation. The second explanation is that there was balance and flexibility already incorporated into the TRIPS agreement through the negotiations that were conducted. And in the end, the agreement is seen as a step forward in strengthening intellectual property, but nevertheless with certain policy options contained in the agreement. The third reason is that the TRIPS agreement really represents multilateral rule of law. If there was no TRIPS agreement, would there be absolutely no pressure, for instance, to change intellectual property rules? There would have been. And that pressure would have come through bilateral means or through plurilateral agreements, as we see what is going on today in the free trade agreement areas. So it's not like you would have been left alone if you didn't have multilateral rule. Today, because there is a multilateral rule of law, you can say there is a standard already set and we are not going to go beyond that. But that is your choice. The fourth reason, and this I find even in Latin America, this would be an important reason, that several countries decided to move in the area of intellectual property and to strengthen intellectual property unilaterally in their own interest, because this was consistent with the move to more open and market-based economic policies. So, Mexico, for instance, long before the TRIPS agreement was signed, Mexico decided to actually change its intellectual property rules in order to attract more foreign direct investment, especially from its northern neighbor, the United States, And they considered it in their own interest to do that because they were moving to more liberal market-based economic policies. Chile did the same thing, did not wait for the TRIPS agreement to kick in before making changes to its own intellectual property laws. So these are the intellectual property rights which are covered under the agreement. You have copyright, which, as I said, covers artistic and literary works. Artistic could be paintings, works of art, and literary works, books, and so on. But this is a very broad definition. It's taken from the Berne Convention. This, in the area of copyright, the TRIPS agreement added very little because the Berne Convention was seen as a standard which was fairly high. The only thing that TRIPS did was to make it quite clear that computer software and databases are included under copyright. Again, this was just making something clear, which was again already accepted by, in fact, well before the TRIPS agreement. US, for instance, covered computer software under copyright, and India even covered computer software under copyright law before the TRIPS agreement. Some Latin American countries, in particular Brazil, did not want to see computer software included in copyright, but in the end, that was not such a major issue. Then there are related rights. Related rights or neighboring rights, as they are called, which cover the rights of performers, for instance, musicians, singers, even actors for that matter, their performances are covered separately under performers' rights. And you have phonogram producers. Of course, nowadays, I'm not sure how many phonogram producers will survive with the internet, but they have rights. The producers have rights additional to the lyricists, the ones who write the lyrics, the ones who write the music, and so on, compose the music, and so on. And you have broadcasters' rights. So broadcasters' rights are those who broadcast television programs, for instance. So they have rights also, and those are not exactly copyright, so they are called related rights. On the industrial property side, you have trademarks, you have geographical indications, industrial designs, which are designs which are not functional designs. For instance, if a car is designed in a certain way that it makes it more aerodynamic, it makes its speed higher, then that is not an industrial design. That would be entitled to a patent. But if a car is shaped in a certain way just for aesthetic reasons, to please the eye, then it would be entitled to an industrial design. Industrial designs are typically for a shorter period than patents, typically for a period of 10 years or so. And that's the TRIPS obligation also. Then you have patents, the subject matter of which are inventions, plant varieties protection, again, new plant varieties which can be covered by certain breeders' rights, but it can also cover certain land races, for instance, depending on the country's law. Then you have topographies of integrated circuits or layout designs, undisclosed information, trade secrets, and test data. And there are other intellectual property rights which are not covered in the TRIPS agreement. For instance, the European Union's sui generis database protection law. That is about protecting databases. That is not covered by the TRIPS agreement. Utility models is another type of intellectual property right, not covered by the TRIPS agreement, except in terms of being protected under Paris Convention. Since the Paris Convention has been incorporated into the TRIPS agreement by reference, utility models are also covered in that sense. Similarly, trade names. Trade names also get covered because they are covered by reference to the Paris Convention. The Paris Convention existed even before the TRIPS agreement came in. And I will show you, this is actually what I like a lot. This is a slide which my colleague has made, which explains it very, very clearly. So you have this circle here, and let us say this is the world of intellectual property. All laws of intellectual property are contained in this blue circle. You have Paris, which is swallowed up by this TRIPS agreement, Bern, which is also swallowed up by TRIPS agreement, and then some part of Rome, and this is the Integrated Circuit Treaty, which is also a WIPO treaty, but it never came into force. So you could say that this was a treaty that was fully negotiated, but never got ratified, and therefore was stillborn. It never actually came into existence. Some parts of the Rome Treaty are included. This is on performers' rights. Only some parts, broadcasting rights and performers' rights. This is about related rights. Only some parts got incorporated, not others. So that's why this circle is smaller. Almost all the substantive provisions of Paris are incorporated. Similarly, all the substantive provisions of Bern. Why was this incorporation technique used? It was used to make the negotiations much easier, to only focus on negotiating the plus elements. So this is all, the space here would all be the plus elements. And to have a shorter but comprehensive text, instead of repeating everything that is already agreed in previous treaties. Some conventions, as I said, have very few elements incorporated, and that is the Rome Convention. So the TRIPS agreement, the main coverage, the main features are that it has a broad coverage, covers almost all of intellectual property. There are certain basic principles taken mostly from trade law and incorporated into intellectual property law, like national treatment and most favored nation treatment, which we will talk about a little later. Minimum standards have been laid down for each category of intellectual property, such as copyright, patents, etc. Minimum standards. There are enforcement provisions which for the first time in intellectual property rights, they cover the enforcement provisions. The WTO dispute settlement understanding applies to the TRIPS agreement. There is only one provision on which there is a controversy and which is not yet applicable to TRIPS, and that is non-violation. That is the concept of non-violation and nullification of benefits. That does not apply to TRIPS. So far, there has been a moratorium granted on that, and that continues to be extended from one ministerial conference to another, WTO ministerial conferences, and the next one will be in Bali next year, and no doubt, again, the issue will be to explain to trade ministers what non-violation means in the context of intellectual property, which is not easy to explain. Even in the context of trade, it is not easy to explain. So this will be another issue which will come up. The TRIPS agreement also contains transitional arrangements, which is about grace periods given to different categories of countries, and it has certain administrative and final provisions. The minimum level of protection which is given in the TRIPS agreement is subject to certain provisions of exemption for developing countries and LDCs, least developed countries. And the TRIPS agreement covers certain provisions which are shall, which are obligations, and certain provisions which are may. Altogether, it is a long agreement and contains 74 articles. Coming to the basic provisions, the general provisions and basic principles contained in part 1, the first is the most important, which is that every WTO member country has the freedom to determine the appropriate method of implementing the TRIPS agreement. Why was this important? Because certain countries of the world had common law systems, and other countries, including Peru, Latin American countries, had followed the civil law system. So this was the first thing that was decided, that it will be according to whatever system you have, so long as this is not used as an excuse not to implement the TRIPS agreement. Again, there was existing conventions that were incorporated, and the concept of national treatment. National treatment was a concept already found in intellectual property law, in the pre-existing intellectual property law, such as the Paris Convention and the Berne Convention. Here, the concept in the WIPO conventions was about giving the same treatment to the owners of intellectual property, whether they are your own nationals, that is, residents, entities registered in your country, or they are foreign owners of intellectual property. But the next concept was something new to intellectual property law, taken from trade law, which is the most favored nation treatment. Why was this incorporated into the TRIPS agreement? Because there was in the past, at the time of the TRIPS negotiations, there was one country, Korea, which had given special treatment only to US nationals. And that was called pipeline protection. Korea was the first country to give this so-called pipeline protection to products which were on patent in the United States but had already missed the window to be patented in Korea. And yet, Korea agreed to give this protection, which made the Europeans very angry. The Europeans were very angry because they said that we should also be given this treatment, and we must incorporate what is called the most favored nation treatment. So whatever advantage or favor you give to one country, you must extend to everybody else, as is done in trade law. So that was one. The second, which I will explain a little more, is exhaustion of rights. Exhaustion of rights is a concept or a doctrine, it's a legal doctrine, which everyone agrees that once a sale takes place, upon the first sale of the product, the intellectual property incorporated in it gets exhausted. The controversy comes up when the product crosses the border and goes to another country. Do the rights revive upon crossing the border? That's the controversial point. And because there was no agreement in the TRIPS negotiations on this, it was left to be decided. It was not subject to dispute settlement. The only thing that was agreed was that it should be whatever your regime of exhaustion, whether you allow for parallel imports or you don't, and I will explain this a little later. What are parallel imports? Whatever regime of exhaustion you adopt, you must adhere to national treatment and most favored nation treatment. Objectives are in the TRIPS agreement. The objective is a title of the article, and that article is Article 7, which lays out that the TRIPS agreement, or the protection of intellectual property, should result in technological innovation and in the dissemination of technology. So it should actually lead to technology transfer in the interests of both the users of technology as well as the producers of technology, and with a balance of rights and obligations to the benefit of economic and social welfare. So this is the gist of Article 7, which was put in, of course, by developing countries in the TRIPS negotiations. You have also Article 8, which is about mentions for the first time in the TRIPS agreement that you can take measures, provided you don't violate any obligation under the TRIPS agreement. You can take measures to protect public health, for instance, to protect nutrition, or to enable some technological development of vital sectors of your economy. So in addition, you can also take some measures to prevent abuses of intellectual property rights. So that is Article 8 of the TRIPS agreement. So this is all in Part 1 of the TRIPS agreement. Then you have Part 2, which is really the meat of the TRIPS agreement. That is the main part of the TRIPS agreement, and it's about substantive standards of the different intellectual property rights which are incorporated into the TRIPS agreement. and that is set out in a certain standard format, you could say. The structure of this section, each section, there is a section on patents, there's a section on trademarks, there's a section on copyright, and so on. Each section has a certain way it is put out. It actually lays out the availability, when should this right be available, what is the scope of the right, and how can this right be used. So there's a reference to the treaty, which is the pre-existing treaty, which is the WIPO treaty, where there's the Paris Convention, the Bern Convention, the Rome Convention. So it starts with a reference to the treaty. Wherever possible, there is a definition of the subject matter. In the case of copyright, it specifically says artistic and literary works. In the case of patents, the subject matter is inventions. There's a definition of the subject matter and definition of the conditions of protection. The conditions for protecting such subject matter are laid down. For instance, not all literary and artistic works are covered under copyright, only those that are original are covered. Similarly, patents, not all inventions are covered, but those that are new and inventive and also useful. These are the three criteria for covering patentable subject matter. The term of protection is laid out. For instance, patents is 20 years from the date of filing of the patent application. In the case of copyright, it is much longer. It goes up to 50 years from the date of creation of the copyrighted work. In the case of industrial designs, it is only 10 years. In the case of trademarks, it can be renewed indefinitely, as long as the trademark is in use. Exclusive rights are set out. There are limitations and exceptions to these rights, which are also set out. And there are some other provisions in certain cases. For instance, in the case of process patent infringement, there's a provision on reversal of burden of proof. So there could be additional provisions depending on the right. But by and large, every section in the standards part 2 is governed by this structure. Then there is one section which is also in the part 2, which is in the standard section, but it's not really an intellectual property right. It is about the control of anti-competitive business practices. And this is in Article 40. It's a part of competition law which was brought into the TRIPS agreement, but only a small part. It covers only contractual licenses where intellectual property rights are involved in that you're licensing out intellectual property right. So when you have such a license, can the state govern certain issues, and can these be called anti-competitive? If there are anti-competitive practices, can these be controlled? And although most of it is really about permissive use of such provisions, so you have the may provisions, not shall. It's not an obligation that each WTO member shall control these anti-competitive practices. It is still important because it is the embryo of provisions at the international level that developing countries were asking for a long time. From the 1960s, in fact, and the Code of Conduct negotiations in UNCTAD, developing countries were demanding this, and eventually it came in to the TRIPS agreement through a proposal made by developing countries that we must have the right to control such anti-competitive business practices when they are incorporated in intellectual property licenses. This Article 40 has to be read along with the permissive clause, which is called principles in Article 8, as well as certain provisions which relate to compulsory licensing, which are given in Article 31, paragraph K, and 37, paragraph 2. TRIPS agreement is the only international intellectual property treaty which contains some detailed provisions on enforcement. Why was Part 3 incorporated into the TRIPS agreement? It's a very comprehensive enforcement provision. And there was some resistance to putting such a lot of detail into this, but eventually it got in. The objective was to ensure that while you have the legal means for right holders, that is, you're giving these intellectual property rights, you should also give the right to enforce them in your territories. Otherwise, such rights could be meaningless, they could be useless. So, for that reason. But this was a very difficult part to negotiate because of civil law, common law kind of differences. For many members, there were actually new obligations. And this is not only for developing countries. For much of continental Europe, there were actually new provisions that they had to bring in because of TRIPS. Border measures did not exist in many countries, nor did provisional measures. Provisional measures is a concept which is known to common law jurisdictions where you can actually get an injunction, and it's a very important concept in enforcement of intellectual property because much of the disputes within a country on intellectual property are actually settled at the provisional level, where you just stop the injunction. With an injunction, you stop the infringement of the intellectual property right. So, Sweden, for instance, Denmark, Greece, several of these countries were taken to dispute by the United States, WTO dispute settlement, in the initial years from 1996 onwards, because they had not actually put into place these new obligations. There was a balance in the enforcement section. The main idea was to protect against abuse of over-enforcing the rights in order to avoid the creation of new barriers to legitimate trade. So while on the one hand it was necessary to allow right holders to enforce their rights in your territory, there was also a need to avoid abuse through over-enthusiastic enforcement, which would then lead to creation of new barriers to what was legitimate trade. So since this was an intellectual property agreement, but negotiated by trade negotiators, there was this concept at the back of the mind of the negotiators to have a balance. And so this balance you can see in this. What are the TRIPS provisions which are relevant to technology transfer? Only two provisions where technology transfer comes in. One is Article 7, which I spoke about, objectives, that the protection and enforcement of intellectual property rights should contribute. The word is should. It doesn't say shall, it doesn't say may, it says it should. So it's something like best endeavor clause, where it should contribute to the promotion of technological innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare, to a balance of rights and obligations. This is language which some say is meaningless, some say this needs to be operationalized. In any case, this language is what developing countries refer to when they want to have something extra with respect to transfer of technology. But the only obligation contained in the TRIPS agreement is in Article 66.2, which says in Article 66.2 there is a specific obligation, just like any other obligation, and that is upon developed country members. And it says that developed country members shall, and here the language is shall, provide incentives to enterprises and institutions in their territories for the purpose of promoting and encouraging technology transfer to LDC members, only to least developed country members, in order to enable them to create a sound and viable technological base. So this is an obligation like any other in the TRIPS agreement, but there is still a fundamental dispute which I will talk to you about when we talk about 66.2 in more detail as to what each of these words means. What does incentives mean? What does technology transfer mean? And what does promoting and encourage mean? So there's a dispute on each of these terms, how it's being interpreted, and what exactly is being done by developed countries to provide this to developing countries. This clause 66.2 is confined only to least developed countries. Peru is not obviously a least developed country, does not extend to developing countries. It was a demand in the TRIPS negotiations to have such a clause for developing countries also, and it keeps getting raised from time to time, but there has been no such discussion in recent times. All of these provisions of the TRIPS agreement came together with a transition period or grace periods. So everyone got grace period, including developed countries who got 1 year from the date of the WTO agreement, which is 1/1/1995. So they got 1 year to implement TRIPS. Developing countries got another 4 years up to 2000. Economies in transition also benefited from the same period. And an additional 5 years was given to introduce product patents for pharmaceuticals and agricultural chemicals. Least developed countries now have up to 2013 to implement TRIPS, and it's possible to have an extension. The last ministerial conference agreed that this would be given serious consideration in the TRIPS Council. And the Doha Declaration on TRIPS Agreement and Public Health extended a period up to 1/1/2016 for LDCs only, for the introduction of pharmaceutical patents, and also which covers undisclosed information and the enforcement of these provisions in LDCs. So they have a grace period. So the only period now left is for LDCs. The rest of the world has implemented TRIPS. Only LDCs have a period which is up to 2013 for all provisions and up to 2016 for pharmaceutical provisions. Since the TRIPS agreement has come into force, work has taken place to establish common understanding or new or modified rules. The first area is TRIPS and public health. There was a Doha Declaration in November 2001 at the Doha Ministerial Meeting. There was another decision in August 2003, which was really called the Para 6 system or Para 6 waivers. It came from Para 6 of this Doha Declaration, and it's about a special compulsory license which allows for 100% of exports, so for public health reasons. So this is called the Para 6 decision. And this was incorporated or accepted to be incorporated as an amendment to the TRIPS agreement in December 2005. The amendment will come into force when 2/3 of the membership of the WTO accepts it. So far we are not near that number, so the date keeps getting extended. Another area is geographical indications, where there is a negotiation which has been mandated under the Doha round, which is to establish a system for the notification and registration of geographical indications only for wines and spirits. So this is under the special session of the TRIPS Council. Another subject is extension of the protection which is given to wines and spirits to all geographical indications other than wines and spirits. That is called the GI extension, and that is also being discussed as a part of the Doha round, but not necessarily an integral part. There is a dispute on that. Article 27(3)(b), which is about protecting plants and animals, or the optional exclusion of protecting plants and animals, has also come up for review. This is a built-in review, and in that context, this subject in which Peru has been very active has come up, which is the relationship between the TRIPS agreement and the Convention on Biological Diversity, the protection of traditional knowledge and folklore. So this part of it is being discussed both in the TRIPS Council as well as in the Director General's consultative process to see where there can be an agreement. Article 71.1 allows for a review of the TRIPS agreement as a whole, and nobody has asked for it, but it is possible to ask for a review of the TRIPS agreement in order to strengthen intellectual property protection further. That has not been used so far. So with that, I stop my presentation, and if there are any questions, you can ask.
Gracias, Modesto Montoya del Instituto Nuclear. He estado revisando los resultados de este tratado de TRIC, ¿no? 1994. Y he visto que en el periodo anterior, en los años anteriores, el número de solicitudes de patentes en el mundo en total estaba estancado, estaba plano, ¿no? Y a partir del 95 ha empezado a subir y ahora se tiene el doble de solicitudes de patentes que en el 94, o sea, ha incentivado las solicitudes en los países desarrollados, pero no ha ocurrido así en los países en desarrollo. No ha habido un incentivo de la creatividad, de la inventiva, de la invención. Algunos países sí trataron de levantar ese número de patentes invirtiendo mucho dinero. Por ejemplo, México en los últimos 10 años multiplicó por 5 su inversión en ciencia y tecnología. España lo hizo también en los últimos 5 años, llegaron a 20.000 millones de dólares, pero tampoco hubo resultados en las patentes. Aparentemente hay algo más profundo como para incentivar la creatividad, la invención en estos países. ¿Usted tiene un poco alguna opinión al respecto? ¿Cómo este tratado ha incentivado las inversiones en los países desarrollados, pero no ha tenido efecto en los países de América Latina, excepto en Brasil, que sí está subiendo permanentemente? ¿Tiene usted una opinión al respecto, una idea?
Yes. Thank you. Thank you very much for your question. I think that's an important observation. I wouldn't say that the increase in global filing of patents is only because of TRIPS again. There has been an increase even before, but it has gone up for many reasons since 1995. And the reason, the term developing countries is very deceptive, because developing countries, of course, includes a large number of countries where patents are being filed by residents also, very, very high, and that includes China. The number of patents in China has gone up very sharply, including by residents, that is nationals, Chinese nationals. Similarly, India, number of patents has gone up, including by residents. Singapore, very sharp increase in patents, and so on. So why do some countries file more patents and other countries not file so many patents? That, despite the fact you're saying that there is increase in R&D done in Mexico, but doesn't result in patents coming out of Mexico. I'm really not.
Neither Spain.
Neither Spain, you said. I don't know. I'm not studying this subject of Mexico and Spain. That's very special to know why it is not happening in Mexico or Spain. But in general, countries that have taken lead in R&D, and I'll show you those figures in my next presentation. I will show you in my next presentation. They have also increased the number of patents in those countries. So while, as I said in my presentation, even here, I told you that there are other ways of incentivizing R&D. And I gave you trade secrets, lead time, there could be after-sale service, all kinds of ways you can appropriate returns from R&D, not just patents. So it's only one of the means, but it's taking away patents, at least where markets are functioning, has not been shown to be, in any case, good for incentivizing innovation. So you can put it the other way around also. Any other questions or comments?
Thank you for your presentation, Mrs. Watal. I have two questions. The first one refers to the MFN clause, the MFN principle. In the case of free trade agreements that doesn't specifically include the MFN clause, is the MFN clause included in the ADPIC, in the TRIPS agreement? Should be extended to the bilateral agreements? And the second question is related to this waiver or paragraph 6 on TRIPS and public health. Did you make any research why members of the WTO didn't ratify this waiver that it's beneficial for developing members, and developing members were fighting and negotiating hardly to get it, and now they don't ratify? Do you know why they didn't do it yet?
Very good questions. Thank you. On the first one, I think it's important to know, this is very, very important, especially for those who are familiar with trade law, that the MFN functions in a completely different way in TRIPS as it does in GATT. So while in GATT, you have an exception in Article 24, which allows for the free trade area agreements to be carved out of MFN, there is no exemption in the TRIPS agreement, at least not for future agreements. There were some agreements which were so-called grandfathered, before TRIPS. So those special agreements, there were very few. Those were taken out under the exception clause. There are certain exceptions allowed under TRIPS for MFN, but not with respect to free trade agreements. So then, what is the result? The result is that every country which negotiates the free trade agreement with United States or EC or the European communities or whatever, is actually giving away intellectual property rights in exchange for market access to United States for whatever products are important to that country. In exchange for that market access, the country negotiating such a free trade agreement is actually giving away intellectual property rights. So the rest of the world is free riding on the higher intellectual property standards which have been created through the FTAs. And despite that, and the interesting story behind these negotiations is when European Union in the TRIPS negotiations proposed this MFN to apply to intellectual property, developing countries like India, because I was there, we thought this was advantageous because if you have no exemption for MFN, then it's very good, because then we cannot be pressured into a free trade agreement or bilateral agreement for higher intellectual property standards, because we can say that, well, if we give you this, we will have to give it to everybody for free, and therefore you cannot ask for this. This is unreasonable to ask for this. And so we thought it would be to our advantage to have MFN and no exception for that. It turns out that we were wrong, and the countries are willing to give away this for free. That it is so attractive to have the FTA that you can give away intellectual property rights or higher intellectual property rights. On paragraph 6, why countries have not ratified so far? It's not that countries have not ratified. I must tell you that if you count the European Union as 28, that is EU plus 27 members, then we have crossed, we've probably reached close to 70 ratifications so far. That is still not enough, because we have to go to 2/3. 2/3 of WTO membership, now with the membership having increased, it goes to 100 plus. And so we still need some more. And now the countries that have ratified include a mix of developing, developed and least developed countries also who have ratified. The reason why others are not ratifying, sometimes it's just administrative lethargy. Sometimes it could be a belief that we may be able to negotiate something better than the paragraph 6 system, a hope that something can be done to negotiate better, which for some reason the WHO promoted and some other NGOs have been promoting it very much. So we don't know what the reasons are, but certainly it's not been used. That is more important, to know what are the reasons why it has not been used. It's been used only once, and that was the Canada-Rwanda case, where Canada, a generic company from Canada, exported antiretrovirals through this paragraph 6 system to Rwanda. The story behind that, as the Canadians themselves have said in the TRIPS Council, is that it was an artificial case. They didn't really need to. Rwanda, if it wanted, could have purchased the same product, the same medicine, apotriabe, which is a triple combination of three antiretrovirals combined into one pill. That they could have got from India at a cheaper price, much cheaper. So they forced the Canadian company to give it to them even lower than the Indian price, and then only they bought it. But they needn't have. They could have actually got it from India. So it was an artificial case. Now, does that mean that it cannot be used or it will not be used? In my view, and this is my personal view, the only reason it will be used, I mean, the only circumstance where it will definitely be used is if the world comes to a situation of some pandemic, like avian flu or swine flu or something which affects the whole world, where generic companies have an incentive, because generic companies are not in it for philanthropic reasons. They are also in the business, like any other company, for profits. They will then find it profitable to manufacture and export to the rest of the world. That's the only way that this system will, that's the only circumstance where I see the system will be interesting for generic drug companies. And fortunately for the world, this hasn't happened. We haven't come to a situation where we've had such a pandemic. There's been a threat of it, but it has not reached the stage of that. So it's a good system to have in place for an eventuality where you need to use it. It is available when it needs to be used. And in our view, in the view of the Secretariat, because we do training programs on this, we do not see it as being so complex that it cannot be used, which is one of the criticisms. Much of the criticism, which came from MSF to begin with, Médecins Sans Frontières, they brought out a publication. They said, this is neither expeditious nor a solution, because the ministers had asked for an expeditious solution. So the title of their publication is neither expeditious nor a solution. And they were actually criticizing the Canadian system in that book, in that publication. They actually criticized the Canadian system, not the WTO system. The Canadian system was adding bells and whistles, which were not required by the WTO system. So that's the other reason. Anyway, yeah. Yes.
My name is Edward, for Ministry. I'd like to ask you, Madam WATAL, a question, but before that I'd like to congratulate you on the very, very good and enlightening presentation. My question refers to you made this, I think, already when I'm going to ask you about the geographical indications, GI extension, and TRIPS CBD relationship. When you were talking about that, you said that both the latter GI extension and TRIPS CBD are dealt with within the Doha round, but there are some controversy if they belong or not to the actual negotiations. Whereas the first of the three implementation issues, namely those regarding the international, let's say, register and identification of spirituous and wine, does belong to the Doha negotiations. Perhaps you could enlighten us about the story. Why is it that two of the three are out or semi-out? of the actual Doha negotiations, and in that sense, what prospects do we see for their inclusion in an eventual outcome of DDA, taking into account some very staunch positions that we have heard in the past by, for example, Switzerland and the EU, saying that there is no DDA whatsoever if there is no GI extension. So they somehow hinge the whole negotiation on agriculture, NAMA, etc., on this GI extension so dear to them. Maybe you could elaborate a little bit on that. Thank you very much.
Yeah. Thank you very much for your question. It's a very interesting question. It was true that developing countries, I mean, even before the Doha round, if we go to the Seattle round, I mean, the Seattle meeting, that was when developing countries, including Peru, in the run-up to Seattle, had made a lot of pressure to actually include not only relationship between TRIPS and CBD, but particularly the protection of traditional knowledge. This was of great interest to many countries, including Peru. And of course, that Seattle meeting broke down. There was no result. It came up again and built up to the Doha meeting. And in that list of implementation issues were many. It was really a very long list. Maybe that was one of the disadvantages of that strategy, because that implementation list was so long. It included practically every agreement in the WTO. It was like a laundry list, some people called it. Some people called it a Christmas tree approach to the whole issue of implementation. And negotiators, I think, or members, as a community as a whole, the membership as a whole, did not know how to deal with this very diverse set of issues. Diverse set. Some were very important and some were not important. Now, to sift between what was important and what was not, there was no time. So, in dealing with these issues, in paragraph 12 of the Doha Ministerial Declaration, eventually there was a fudge, there was an agreement which had constructive ambiguity, or maybe not so constructive. There were two paragraphs, one saying those where there is a clear mandate, they will be dealt with in the special session. And for the other issues, they will be dealt with in their respective WTO bodies. And there will be a report made to the TNC at the end of 1 year. That was the agreement. This was called paragraph 12B. So TRIPS and CBD and traditional knowledge came under the paragraph 12B, which was a report, a discussion in the TRIPS Council and a report to the TNC. Now, this was meant to be for all the other outstanding implementation issues, of which there were plenty. It was numerous. Eventually, the only two implementation issues or outstanding implementation issues that survived were the TRIPS issues, that is GI extension and TRIPS CBD. These were the only two that survived. Out of all, the whole list fell by the wayside. Nobody pursued any of the other implementation issues. So now what happens is these two issues are dealt with on a separate track, because obviously there was no agreement in the discussion in the TRIPS Council. At the end of 1 year, the report didn't say anything to the TNC. The compromise was that the DG, wearing his hat as Director General and not his hat as Chairman TNC, he would take up these two issues and see how to deal with them. Of course, he was meant to take up all the issues, but as I said, over the years, he delegated it to his deputies, and over the years, they all fell off the table except the two TRIPS issues. In my view, and I'm sure you know much better than me because you have been in the deck, you dealt with these issues in Geneva. If the members stand firm that nothing is going to be done without a decision on these two issues, they are willy-nilly, whether you like it or not, part of the Doha round. But if the members decide, no, they're not important to us and the other issues are more important, that is, the demanders for these two issues are willing to compromise, then they will not be part of it. So I think a lot of it will really depend on how strong the proponents of these two proposals are in dealing with this issue. And nobody can ignore it if there is no consensus, because eventually the whole package, the single undertaking, will only come together when it comes together. It will only come together by consensus. And if there is no consensus, then it will remain outstanding. So we will see how it plays out. At the moment, of course, we are nowhere near that stage. A lot of people look upon this as end game, the end game. It's never going to happen before that. We'll see what else is on the table and so on. So at that time it will come up. But we in the Secretariat have to be prepared to see, where will be consensus language, or what can people live with. And at the moment, the positions are so far apart and nobody has revealed their cards as to where they're willing to compromise on both the issues.
Hello, my name is Gabo, I'm lawyer. I don't know if you could tell us some new about this discussion between some countries related to try to include in TRIPS some specific mention of the access to genetic resources. And I don't know if you could tell us maybe some interesting experience of some mega diverse country which who is trying to resolve this, maybe out of TRIPS. Maybe like Costa Rica with India. Maybe, I don't know if you could tell us about some other experience interesting in this case. Thank you.
Thank you. Let me briefly, because I think we are also running out of time, but let me briefly answer your question. Yes, this is a very important issue. This is one of the outstanding implementation issues. It goes under the heading of relationship between the TRIPS agreement and Convention on Biological Diversity. A group of countries called the Disclosure Group, in short, they have made a proposal to amend the TRIPS agreement to incorporate a new article, 29 bis, that is the article that they want, Article 29 bis, which would oblige all patent applicants to disclose in that patent application the country of origin and whether they have prior informed consent and have shared benefits or made some benefit sharing arrangements with the country of origin. So they must say all this in their patent application, and that is an obligation on patent applicants. So that is the proposal. This proposal, of course, is controversial. There is no agreement, as you can imagine. United States is at the one extreme opposing this. They don't want to see the TRIPS agreement amended. They have their own reasons. They have given their argumentation why they don't like it. So we are nowhere near an agreement. There are other forums where there is negotiation going on. One where an agreement has taken place, and that is in the CBD itself. The Convention on Biological Diversity has negotiated what is called the Nagoya Protocol on Access and Benefit Sharing. That happened in October 2010. And that protocol is meant to actually encourage benefit sharing, where access is given to genetic resources. It includes, for the first time, traditional knowledge also associated with biodiversity. So it is quite an interesting agreement. There are, of course, views it could have gone further, it could have done more, but it opens the door. And my understanding is that Peru and other countries in the position of Peru are happy that they have opened the door to something that can come later, can be developed later. So that is an interesting agreement. The third forum where this is being negotiated is the World Intellectual Property Organization, WIPO, also in Geneva, where they have an intergovernmental committee on genetic resources, traditional knowledge and folklore, where this is being negotiated in the hope that there would be an agreement on traditional knowledge, protection of traditional knowledge, as well as protection of genetic resources. We don't know how far they will go, but that is an ongoing process.
Thank you.